Evictions have changed in San Diego. This is a guide for renters and landlords where we discuss the brand new Residential Tenant Protection Ordinance in San Diego. We're going to run through which properties are exempt from the Residential Tenant Protection Ordinances, what needs to be given to the renters in order to keep the exemption. We're going to talk about the changes to evictions, particularly no-fault evictions. We're going to discuss the Relocation Assistance that will be due to renters, requirements for notices, buyout agreements, and make sure you stick around to the end where we talk about stiff penalties for landlords who don't follow the law. Hey there, Christian Walsh, real estate agent with Wire Associates. We have been helping California renters and landlords understand their rights to try and keep things from going wrong. And remember, I can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. The Residential Tenant Protection Ordinance, or RTP Ordinance for San Diego City, was signed into law on May 25th, 2023, and went into effect on June 24th, 2023, and makes some big changes in San Diego City. One of the things to understand is it only covers the city of San Diego. It does not cover any areas outside in San Diego County or other incorporated areas in San Diego County. Let's dive into the San Diego Municipal Code. And I know I scared off 99% of you with those words, but let's go directly to the source so we can see what is actually in the Residential Protections Ordinance. And landlords, by the way, you may say, oh, I'm going to let my property manager handle this. Well, number one, your property manager probably doesn't know about this. But number two, under definitions, the landlord means any person acting as a principal or through an agent. So if something goes wrong, you can't just blame a property manager. We're going to show you what the potential punishments could be if something goes wrong. All right, running through this quickly. Keep your eyes open. There's good stuff in here, I promise. We're going to first start with exemptions. And by exemptions, we mean the properties that this does not apply to. And this list is very similar to the list that you'd find under AB 1482 or the Tenant Protection Act of 2019. We have other content on that if you're not aware of that. That is another important one for tenants and landlords. So diving in here, you can see short-term residential occupancy. So short-term tenants are exempt. This is not meant to cover vacation rentals, short-term rentals. That's important. And there's a lot of categories that won't apply to most people in here, but the few important ones I want to make sure you see is a duplex, so a property containing two separate dwelling units within a single structure, in which the landlord occupies one of the dwelling units as the landlord's principal place of residence at the beginning of the tenancy, so long as the landlord continues in occupancy. So what this means is the duplex has to be one structure, can't be two houses on a lot. As long as the landlord lives there as their primary residence, the tenant moves in after the landlord, and the landlord stays there. That is a property that will be exempt from this San Diego ordinance. Another big category is housing that's been issued a certificate of occupancy within the previous 15 years. Another one that's similar to AB 1482. So newer construction, no matter how many units, could be a house, which is exempt anyway, or it could be 100 units. As long as it's 15 years or younger, and that's a rolling date, it is exempt from the San Diego Renter Protection Ordinance. Okay, pay attention because this is the next big category, and that is a separately alienable property. So that would be a single family home or a condo. It can be sold on its own. And these properties will be exempt from this ordinance as long as the landlord is in a residential investment trust, corporation, LLC, etc. Those are similar to AB 1482. And if you have the house title in a trust, or you're an LLC, but it's just two people or a single person, those are still exempt. They're trying to prevent corporations who own tons of homes from being exempt from the law. The other huge key to the exemption under this particular section is that the tenants have to be provided written notice that says exactly this. So if the tenant is not provided written notice of the exemption, the property is no longer exempt. The landlord will lose the exemption. Moving into the just cause required for termination of a tenancy. This is really what the Residential Tenant Protection Ordinance is putting into place, is just cause protections for renters. So just cause termination of tenancy is broken down into two categories. There's at fault and there's no fault. And by fault, we mean whose fault? fault? The tenant's fault. So at fault just cause termination of tenancy would be the tenant has done something wrong, like they stopped paying rent, they're using the property for an illegal use, committing waste, etc. These are the reasons here for an at fault just cause termination of tenancy. Landlord does not owe relocation assistance. They can evict. So if a tenant stops paying rent, they can evict. These are the reasons here for at fault. What this ordinance changes are the no fault reasons. And again, by no fault, we mean the tenant hasn't done anything wrong. The landlord wants to terminate the tenancy of a month-to-month tenant. There are a few specified reasons under this ordinance that a landlord can terminate a tenancy for no fault. One is the landlord moving in, and that is only if the language in the lease allows this. And as far as landlord move-in, it could be the landlord, it could be a spouse, domestic partner, it could be a parent, grandparent, child, or grandchild. That straight line. And it must be in the lease. The lease has to say that the landlord's family can move in. The next reason is the landlord is going to remove the property from the rental market. It will not be a rental anymore. Then the third one is a government order. And number 4, the landlord seeks to demolish the rental unit or do a substantial remodel, but there are very strict regulations for the substantial remodel. Number 1, the landlord's going to have to pull permits. We'll talk about that more in a minute. They're going to have to post the application for the permits within 3 business days at the property so the resident knows. They're going to have to serve those permits to the tenant once they have them, and it's going to also include the notice, usually a 60-day notice. It will also need to state the reason, the type and the scope of work that's going to be performed, and why it can't be done with the tenant there, why it requires the tenant has to be out for 30 days. And by the work that's done under a substantial remodel, this section here mirrors the state's definition of a substantial remodel, which is 1946.2. And a substantial remodel modifies the structure. It requires electrical, plumbing changes, mechanical system changes, things that require permits. Could be lead-based paint, mold, or asbestos remediation as well. Basically, things that add up so that the tenant can't stay there while the repairs are being done and will take a minimum of 30 days. That is a substantial remodel. That's what you'll need to do to qualify under this section. And there's more. I haven't lost you yet, I hope, and that is there's special notices that a landlord will be required to give. As mentioned, the exemption notice. If the property is exempt, the tenant will need to receive that. And if the property is not exempt, they're going to have to receive this special notice in addition to a guidebook that has been created by the commission called the Tenant Protection Guide. Here's a quick look at the Tenant Protection Guide. I have a link to the main page so you can download this, but it may continue to change, so make sure you give your tenant the latest version. And don't forget the notices that we've discussed, whether it's for exemption or for properties subject to the RTP, must be given to all tenants, and that includes existing tenants. So if it is a renter who is in place June 24th, 2023 or before, you have 90 days after that date to give the notice and to give the tenant guide. Any renewals for existing renters or new leases must receive the notice and the renter guide at the time of signing the lease. And if you're serving notices to terminate tenancy, whether it's at fault or no fault, there are new processes to follow for that as well. So if it is an at fault reason, I recommend you hire an attorney. And if it's a no fault reason, I recommend you hire an attorney. You are going to have special process to follow for either one of those. Just understand that the landlord shall provide written notice to the commission for the at fault or no fault termination of tenancy. And they have 3 days to get that to the commission. This will not start until the online portal is set up on the website. As this video is being shot, they're in the process of setting up that portal. 30 days after that portal is ready, it will be required that these notices are also served to the commission. For no fault terminations, the landlord's going to have to provide a description or reason for the termination for no fault. The landlord's also going to have to give an update on how the relocation assistance will be paid. We'll talk about that in a minute. You have 15 days as a landlord after the notice is served to give it to the tenant. or you can waive the rent equivalent for the relocation assistance, but you have to let the tenant know which one you're doing. Also, on the no fault notice to terminate tenancy, it must state that a renter has 30 days to let the landlord know that they'd like to re-rent that unit in the event that it is available for rent again within 5 years after their tenancy is terminated. And this is specifically for number 1, 3, and 4. It does not apply to removal from the rental market, but it applies to the other 3 no-fault reasons to terminate a tenancy. If the renter notifies the landlord within 30 days of receiving that notice that they would like to exercise this option, the landlord is able to screen the tenant at that time. It also does not state that the rent must be the same, but I recommend discussing this with an attorney before moving forward. How much is the relocation assistance in San Diego City? Well, it's all laid out here. This is, again, for no fault reasons for termination of tenancy, not for at fault. If the tenant has missed paying rent, they don't get relocation assistance. The landlord will have to provide, in most cases, a minimum of 2 months' rent as relocation assistance. If the tenant or any of the tenants are senior or disabled, the payment will then be 3 months' rent for relocation assistance. And again, that's either due within 15 days of the notice or waiving that equivalent of rent. The next big section in the Residential Tenant Protection Ordinance is related to buyout agreements, otherwise known as cash for keys, when a landlord offers money to a tenant to go ahead and have them move out. Now, there are very strict rules that must be followed. They're laid out here. It needs to be in writing, the agreement, and on that agreement, it needs to state that it's optional. The tenant does not have to accept the buyout agreement. The other important thing is the buyout agreement cannot be for any less than the required relocation assistance. If it is, it invalidates the buyout agreement, and there may be damages that the renter couldn't go ahead and extract from the landlord. Coming to the end of the Residential Tenant Protection Ordinance, mentions retaliation will not be tolerated by the landlord, and it goes through a list of remedies. It's important to understand as a renter and a landlord that there can be big payments that go out if a landlord doesn't follow the law. For example, E, any landlord who fails to provide relocation assistance as required shall be liable to the tenant for not less than 3 times the required relocation assistance and actual economic damages. So you could see where a landlord who would owe 3 months relocation to a disabled or senior tenant now has to pay 9 months worth of relocation plus actual economic damages. Big penalties. Make sure, landlords, that you understand the regulations. You're using an attorney who understands the ordinance. Big penalties for landlords who do not follow the letter of the law. Make sure you leave your questions about the San Diego Residential Tenant Protection Ordinance below. Also, subscribe to our free weekly email newsletter so you don't miss any updates on this ordinance and all the other ones throughout the state of California. And if you found this video helpful, you are going to love this next one. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, Berkshire Hathaway Home Services, and we want to hear from you.